Hi, Michael Kushner here. Welcome back to HOA Hell, the podcast. With me today is my usual guest and senior associate at MBK Chapman, Sam Kill. Sam?
Hello, Mike.
Welcome back again.
How are you?
I'm fine, thank you.
Thank you.
We were talking for a while before about this episode. This episode, we're going to really hyper-focus on one issue. We're going to talk about special assessments and their passage as emergencies, and how HOAs throughout the state use the emergency excuse to justify illegal special assessments.
Right.
Special assessments are a normal part of HOA business. They're designed to fund unexpected expenses that arise or emergencies that arise. That's what they're for.
Exactly.
But when a special assessment runs over a certain number, in this case, it's 5% of this year's budget, right? You typically need to have a vote of the membership. It's got to go up for an election, right? The problem is that one of the exceptions, and it's a good exception, is in the case of an emergency.
Yeah.
But it's the abuse of that exception that is the issue today.
Way overused.
Right. So that's what we're going to focus on today. Now, let me start with just a quick little story. Some of you might have read this in the paper. It did make the news just a few months ago. There's an HOA in Modesto, California, and they were hit with a $25,000 per household special assessment. Now, the issue was, out of all the homes that were there, a lot of them had balconies. Some didn't have balconies, but 8 of the balconies were red tagged by the city. Red tag by the city means you can't go on this. It's going to collapse and kill people. It's that dangerous. That is an emergency. Okay. So the HOA, without any notice, well, no prior notice, and certainly no vote, no meeting of the homeowners, passed this special assessment. The problem is, number one, the failure to or the emergency that led to those 8 balconies being red tagged was really the fault of the HOA because of systemic years, over a decade of complete failure to maintain.
Right.
We talked about that. We have a podcast coming out on the failure to maintain.
I mean, shocking deferred maintenance.
Shocking.
Red tag. Yeah.
Shocking deferred maintenance. Okay. So that was the real issue. But more importantly, the price tag of $25,000 per household was much more than was necessary to repair the 8 red tag balconies. It was to make repairs and inspections and maintenance of all the balconies. But only 8 of them were red tagged.
Can't do that.
That's the problem. Anyway, it was in the news for a few reasons. One of which was a lot of the people there were either retired or simply didn't have the wherewithal to come up with $25,000.
Right.
And the HOA, what they were doing was completely illegal. And that's why it was in the news. So we're going to use that as an example today. But that happened. But it's not just Modesto. It's happening all over California. The newspaper doesn't pick up all of the stories, but we see them. We see them here at the office, okay? And then, of course, what happens is it forces, basically, when you do these illegal special assessments, it forces the rest of the homeowners in that community to clean up the mess of prior boards. And that's not the way it's supposed to work. So it's especially egregious when HOAs use the emergency exception as a cover-up for their malfeasance, for their gross negligence. We see that more often than we'd ever like to. When you start to peel back the layers and you find, oh my goodness, balconies used to be inspected every year or twice a year by a contractor, and then they decide to save money, and so they have them come every 3 or 4 years or whatever it was. You start to see that when you start looking at the documents. The emergency covers all that up because if they can get it repaired before that happens, before somebody takes them to court and gets those documents, or before a homeowner thinks of using Civil Code Section 5200 and getting the documents themselves, you start to uncover what's being hidden because it's a great way to mask years of malfeasance. So anyway, bottom line is boards are starting more and more to pass these special assessments without following the law. Now, let's make no mistake. We're not going to cover what special assessments are today. That's not today's episode. I'm only going to say that a special assessment of less than 5% of that year's budget, okay, that can be passed by the board without a vote of the people. But if it's beyond that, it needs a vote, except in an emergency. And there are 3 kinds of emergencies, which we'll talk about in a minute. Okay? So let's talk about that. Let's go into that. Okay? The way it's supposed to work in the law is you have something that has to be repaired. The amount of repairs in total is going to be more than the 5% figure. The default is it needs to be voted on. Right?
Right. Exactly.
That's the law. Now, exception number 1. It is a threat to life and limb. It is such a dangerous condition that it is an immediate threat. Okay? Red tag balcony would fall under that.
Absolutely.
Because red tag balconies are what lead to,
collapses.
Like we talked about in Berkeley.
Exactly.
Or in Florida.
Right.
Okay? It had the inspector happen to come the day before that party in Berkeley, they probably would have red tagged that balcony.
Absolutely.
And of course, this is what happened. So when you've got a red tag balcony, you don't want to walk on that balcony.
It's unsafe.
Because it's unsafe. They are saying somebody could die. That is an emergency. Nobody denies that. Okay? How it got there,
you don't get there overnight.
You don't get there overnight. It takes a lot. Unless a tree falls on it.
Especially with 8 of them.
Yeah.
Like in
yeah.
Modesto.
Yeah. If a tree falls on it after a storm, you get there overnight. But other than that, you're right. You don't. It takes years of systemic neglect. But it's still an emergency. So that would qualify.
Yeah.
What's the second one?
The second one is if you go to court, get a court order essentially to approve it, and then that way you override the 5% voting of the membership requirement.
Any court order. If a court orders the HOA do this,
right,
then they have to fund it with a special assessment. Then.
And there's typically a prove-up element. You can't just go to court and just claim anything. You have to.
Well, the judges are going to grant your motion.
There's an immediacy element to it, so therefore they'll grant it. Yeah.
The court will grant it if you've got sufficient evidence to justify it, but they're not just going to grant it for no reason.
Right.
At least you hope. That's supposed to be that way. And do you remember the third one?
Well, the third one is if it's something that was unforeseen and couldn't have been reasonably accounted for
at the time of the
budget. Exactly.
Right.
And so if it's not part of like a routine maintenance issue that has been deferred and neglected, or board has been derelict for many years, or prior boards have been derelict, right? Because
so they couldn't use that third one to say, well, we couldn't have foreseen that we would need to do the special assessment because it took years to get to that point. They couldn't do that. So that third one would be out.
Right.
They can use the emergency one, the first one I talked about, on the 8 balconies if we're going to Modesto.
There's a heightened standard, and then we also discussed this briefly earlier. The board will have to justify that by way of a resolution. So they have
we're going to get to that. Let's not jump ahead. We're going to get to that, okay? So those are the 3 exceptions. Court order, a true emergency, or at the time that the budget was being done for that year, it couldn't have been reasonably foreseen.
Exactly.
Okay? We didn't plan for it. We weren't, it slipped our minds, or, stuff like those lame excuses like that.
SB 326 was not in place yet.
Yeah, right. The balcony law wasn't in place. Those don't count.
No.
That's mismanagement, not an innocent mistake or an innocent, we couldn't foresee it.
Right.
Now, let's talk about modern pattern of abuse. And now we're partly getting into what he was talking about. So what we're seeing, and we talked about this in our balcony, in one of the first podcasts we did on the balcony law, we're seeing a lot of HOAs impose these special assessments because even though the balcony, it was supposed to be, the balcony law was supposed to go into effect, like everybody had to have their first inspections done by the first of this year, 2025. They actually extended that. Their legislature extended that to January 1st of 2026. So it was extended a year. But it didn't stop HOAs all over the state from special assessments like up the yin yang, which is what we were seeing. $20,000, $30,000, $40,000, $50,000, $60,000 per household. Yeah. We saw them all in that between 20 and 60. So we're seeing a lot of that now. That's not what I'm talking about here. What I'm talking about is what happened in Modesto. Okay, let's talk about what happened in Modesto. You had years of systemic abuse that resulted in lack of maintenance and the deterioration of scores of balconies in this community. But of those, only 8 were red tagged. They were all inspected, but only 8 were red tagged, meaning, and just for the sake of discussion, because I don't remember how many how many homes there were in that community and how many had balconies. So I'm going to make the number up for a hypothetical. Let's say there's 100 homeowners, 100 members of that HOA, and 50 had balconies. So in my example, out of the 50, only 8 were red tagged. That meant 42 weren't. That special assessment they passed of $25,000 per household was to cover the repair and or replacements and or maintenance of all 50 balconies. Yeah. That's the illegal part. There's no dispute that the 8 that were red tagged were emergencies under the law.
Right.
And therefore, a vote was not necessary of the homeowners. And what was necessary is what we're going to get to in a minute, which is what he just raised, which is the resolution. There's no dispute there. It wouldn't have passed because there was no court order, so it wouldn't be that exception. And it wouldn't be that it was not foreseeable because it was years of systemic abuse. That's foreseeable. Mm-hmm. You don't take care of it, it's going to fall apart. There you go. But it was an emergency. But the assessment, although that could be imposed on all the homeowners because this was exclusive use common area, which is the maintenance responsibility of the home in this community, although everybody needed to pay, the amount should have been only enough to replace or repair whatever they're doing with the 8 that were red tagged. The other 42 that absolutely need work to avoid a future red tag need to go through an election. That's the issue. They tried to fund it all as an emergency instead of the 8 as an emergency, and that they can't do, and that's why it made the news. Right. Now, when an HOA truly falls under the scenario that it is a true emergency, okay, or if it falls under the other exception, it was not reasonably foreseeable, and it came up after the budget was passed, either one of those, then, and it's over the 5%, because remember, when it's under the 5%, then they don't even need an election. They don't have to worry about it. Right. If it's over the 5% and one of those exceptions applies, the board can vote and do the special assessment. But before they do that, they have to pass a formal corporate resolution.
Exactly. Yeah.
And they have to, when they deliver the assessment news to everybody, they have to deliver a copy of that resolution signed by the board. Mm-hmm. And that's also what a lot of boards don't do. They just ignore that. No. But if they ignore that step, it's not legal. Mm-hmm. They have to dot their I's and cross their T's.
Right.
When you are basically shortcutting a process that's been implanted by the law, and if you're rightfully shortcutting it, there's some requirements.
That's a big defect when they skip that step.
Yeah, it's a minor thing to get a resolution. Right. If the board passed it, then they'll pass the resolution. Mm-hmm. But you got to deliver it. You got to actually go to the step, the corporate formality, and then you have to deliver that with the assessment. Mm-hmm. Hey, everybody, we have 50 homes that need balconies because we've had prior boards that have just messed up.
Right.
We're here to take responsibility. However, 8 of these 50 were just red tagged. So under our emergency powers, we are going to issue a special assessment sufficient to fix those 8. And then we're going to be holding an election or vote in the near future on to whether or not you all will approve a special assessment to fix the other 42.
Because it exceeds the 5%.
Because it grossly exceeded the 5%.
Yeah.
Now, here's the thing. If fixing the 8 balconies didn't exceed the 5%, they wouldn't have even had to rely on the emergency. Mm-hmm. But it did anyway.
Right.
Okay, that was the point. It would have anyway, but then they tried to be sneaky.
Yeah.
Okay? Mm-hmm. And you can't do that. And that's the part you can't do. So the board in the Modesto is saying, well, we didn't have a choice. Well, yes, you did. Do it right. Pass the resolution and apply the emergency to the 8 that are emergencies, and then go through the process of the election and the vote for the other 42.
Right.
Now, again, those numbers I made up, but that was the issue that happened in Modesto. Now, we have procedural safeguards, don't we? Mm-hmm. Okay, that are in place that boards often ignore. Okay, and it's what we just said. They ignore the resolution process, which is an afterthought, to be honest. Mm-hmm. Don't you agree?
I agree, and it's a head scratcher for me. I mean, do you not consult with legal counsel on these big ticket items? You absolutely should.
Right.
Yeah.
It's not optional.
Right.
It renders illegal what would have otherwise been justifiable.
I mean, it speaks to their lack of transparency. It speaks to numerous issues, opening them up to a lot of mistrust from the membership, right?
And rightfully so.
Rightfully so. I mean,
because people don't want to be taken for a ride.
Yeah. I mean, people oftentimes will have some semblance of knowledge that their balconies, in your example, were not red tagged, so they will be disproportionately impacted, and naturally they'll ask questions. Why me? Why an emergency? It's not a health life
And
safety
to be
issue.
honest, most lay people, myself included, I'm not sophisticated when it comes to construction stuff. I don't know that a balcony, I've never had my balcony, off the master bedroom. I've never had that inspected. I should probably have that inspected. And things out there all the time. I never inspect it. I have no idea. I never go out there. All right. So I don't even know if it's safe. I mean, it was inspected when I moved in, but that was several years ago.
Yeah.
Maybe I should get that looked at. The point is, most people don't understand whether or not something, how it should be inspected. That's
true.
That's why we hire, that's why HOAs are supposed to have professionals. And that's why there's actually a new law that is, I think it's being debated now, or I don't know what the disposition is, regarding the requirement of having management companies actually be licensed. Like right now, you have to disclose whether or not your management company has a license, but it's not mandatory that they have certain license. But I think that's going to change. I could be wrong, so don't hold me to that. I just thought I read that somewhere. But the point is, lay people have no understanding of what it takes. They do understand red tag, and then they know that theirs wasn't. And so why am I paying $25,000? Why are you charging me to fix my balcony now when my balcony's fine?
Right.
In other words.
And just to be clear, the board includes those lay people. They're lay people as well.
That's who I'm talking about.
And so it makes it even more heightened that they are transparent in producing the basis for these resolutions. And if there's a report by, let's say, like someone with a structural engineering background, an architect,
who they hired,
present that, to share that throughout the community.
I mean, that's the whole point of the balcony law, folks, is to have the law we talked about in one of our first episodes. The law requires a qualified, licensed professional to do the review and analysis, and if repairs are necessary, a report discussing it. The reason for that requirement is so that the board was getting information from people that do know, and not relying on Facebook or
an article they just read.
Facebook engineering 101, right? You have Facebook medicine, right, where they talk about some of the wackiest medical theories that make their way, and it's like, I think Reddit has a subreddit called Facebook Medicine. It's hilarious, actually. Okay, these are real engineers. These are real licensed professionals for a reason. Otherwise, that balcony law would be a joke. So, what can you do, folks? You're homeowners. What can you do now? You're living in the reality that we have now, which is boards, because of this balcony law in particular. That's not the only reason, but it's a good one. Boards are skirting rules all the time now, and it's epidemic. So what can you do? Well, first one is his baby.
Oh, yeah, document. And that is, well, it's a series of steps you can undertake to do that effectively. One is send a written request to your board.
Asking them what's going on and how they justify
what's going on.
Yeah.
Ask for the documents. Ask for a copy of the inspection report if they haven't provided that yet.
Give me documents that show me that this is an emergency and not just something that needs to get done pretty quick.
Exactly.
Why is an emergency? Remember, is a threat to life and limb.
Safety, yeah.
Okay, it's a safety, physical harm or death situation.
Right.
Okay.
And the red tag, speaks directly to.
And by the way, an emergency can constitute if it's gonna. If something is going to fall that would cause millions of dollars in damage, that would be an emergency too.
Exactly.
But that's not the norm. So that's why I'm not including it.
There's a reason that there's also reporting requirements to code enforcement building safety with the city. If there's any structural wood rot, etc., they have to affirmatively report. And we covered this in one of our other episodes.
In the balcony one.
The balcony one.
Yeah.
So requesting additional details
should be easy.
And the basis for qualifying it or designating it as an emergency, that would be a great starting place.
And do it in writing. Don't do this on the phone. Yeah. Nothing that happens on the phone or in person is it was ever said.
And one thing I say consistently is, even if there's an incidental conversation, let's say in the common area, you run into a board member.
Confirm it in writing after.
Memorialize, confirm with writing.
Yeah, just send an email saying, hey, John, pleasure to talk with you today. Just to reiterate what we discussed, boom, boom, bam, bam, done.
Exactly.
Now it's in writing. Okay, now here's the thing. Crest all documents, agreed. Right. You must. Make them justify it. Right. They can't tell you it's none of your business, and they can't tell you, well, it's private or it's confidential board information. That is not true. Right. That is a complete lie. Right. Okay? Ask for the board's written resolution.
Oh,
okay?
Yeah.
Say, give me a copy of the resolution.
Right.
Okay? They have to give it to you. If you didn't get it with the special assessment, it means they didn't do it. Mm-hmm. Now, there's nothing stopping them from doing it after the fact. How would you prove it? It would be illegal if they did that because there'd be no notice for that executive session meeting. They'd have to have an agenda to do that, and you'd be able to see that.
Yeah.
So if they lied and did that, there's no way to catch that, but that is what it is, okay?
Right.
Also, if that doesn't work, or it does work, they give you the documents you asked for, and let's say they give you the resolution, but you don't think it qualifies as an emergency, even though they gave you their supporting doc, you can demand, if you think it'll be helpful, IDR.
Yeah.
Internal dispute resolution. Internal dispute resolution is free. It is mandatory. If you ask for it, the board is mandated by law to do it. And if they don't, that's great because that's just a weapon we'll use later. Okay. And it can be helpful at times. It is almost never helpful if there's a bad relationship with the board or a contentious relationship with the board, or the board specifically doesn't like you because you keep holding their feet to the fire, or the board is actively engaging in nefarious conduct. They don't like a light shined on them. They're like little rodents that scurry when the light is shown on them. They're the ones that hide under the rocks. So they hate it when there's a light shown. And so if you're in that scenario, demanding IDR is not going to be helpful. But it's certainly an option, and it's an option you can exercise yourself before you ever think of coming to us at MBK Chapman. Okay. Now, some people do hire us to walk them through IDR, and that's okay. We're happy to do that, but we don't think you need to do that. Okay. The next step, though, would be now you come to us because ADR is the next step if it's required, and it probably is because I have a feeling we have injunctive relief that's going to be required here. But where ADR is a necessary step, where it's a legal hoop that you have to jump through before you can even take it further, we strongly recommend against homeowners doing ADR demands on their own. Lay people just don't have the experience about it's a very statutory based letter, and it is very easy. And I'm going to do this in my next podcast. We're going to talk about this in particular, so I don't want to go into too much detail now. Suffice to say, it's very easy for a homeowner who handles an ADR demand on their own to waive certain rights or not take advantage of certain timelines that are given in the statute because they don't know about them.
Right.
I strongly recommend against doing that. I think any competent lawyer in this field that has expertise here would say, don't do ADRs on your own. Okay, you come to us at MBK Chapman. We've done thousands of them. We know how to do these. Right. Okay, so those are the weapons you have to hold your HOA accountable. And when you do that first weapon, which was send a nice friendly letter, please justify the emergency. Give me copies of all the reports that you relied on as a board to make a decision that this was an emergency and therefore did not qualify for a vote. Give me all of that. Okay, they're going to already know right off the top, even if they've never dealt with you before. Okay, well, this person's checking our work. Okay, that does help. Just that alone helps. But follow up. If you then get those things, if you don't get them, you come to us, we'll get them for you. If you do get them, you look at them and then decide for yourself if you think they're right. If you don't think they're right or you're not sure, consult with us. Doesn't mean you're going to hire us to handle anything. Maybe you buy an hour of our time and we look at what they sent you and we agree or disagree with you. Yep. And at least you'll know where you stand. So either way, be proactive. It's the only way you can protect your rights. Because if you're not proactive, you don't exercise your rights, you might as well not have them, right?
Indeed.
So what's the takeaway here? Pay attention, document everything, and question if they're coming to you for money that wasn't planned for, i.e. special assessment. Don't just write a check. Learn a little bit about how it came to be. You should already have all your budget documents from they're supposed to be given to you every year. So if you go and multiply the amount of money that they're asking you to pay by the amount of members in your homeowner association, you'll have a total, and then just do a simple math calculation onto the budget and find out if it's more than 5%. If it is, it needed a vote. And if there's no vote, there better be an emergency involved. Real simple. That's the takeaway here. Yeah. Think for yourselves, be proactive, and when none of that works, you call us at MBK Chapman. This has been another episode of HOA Hell. If you like this episode, please hit the like button. And if you haven't already done so, we'd love to have you subscribe. If you want to leave a comment or ask a question, we'd love to hear from you. Until next time, have a wonderful day.